Welcome to this webinar. I'm Pamela Cross, a lawyer working with the Barbara Schleifer Clinic. We're in Toronto. The focus of my work is on providing legal support to survivors of sexual assault. This webinar is intended for frontline workers who are not lawyers, so you can provide some initial legal information to any of your clients who have been sexually assaulted. We hope that you'll then consider referring your clients to the Independent Legal Advice Program at the Schleifer Clinic, which I'll talk about more shortly. Contact information for the clinic appears on the final slide of the webinar, and we encourage you to connect with us if you would like more information or would like to work with us to develop an in-person workshop tailored to your organization's specific needs. The Barbara Schleifer Commemorative Clinic is a specialized clinic in downtown Toronto, serving women who have been subjected to violence with legal advice and representation in the areas of family, immigration, and criminal law, professional counseling, and multilingual interpretation in more than 200 languages. We serve more than 4,000 women from diverse communities each year. Our wraparound service model is unique, and we bring more than 30 years of legal and counseling expertise in violence against women to our work. While we're based in Toronto and largely serve women in the GTA, we can serve women outside Toronto by telephone. The goal of this webinar is to increase your basic knowledge and awareness so you can provide initial support to sexual assault survivors who have legal questions or issues. We'll do this by discussing a number of things. First of all, we'll look at legal options and issues for survivors. And then we'll talk about some of the common legal responses, including criminal law, making a claim to the Criminal Injuries Compensation Board, reporting a sexual assault to a professional body, for example, the College of Physicians and Surgeons, bringing a civil lawsuit, making a claim to the Human Rights Tribunal of Ontario, how to manage a sexual assault that happens at a university or college. We're also going to talk about what the survivor needs to know right away. This webinar is not intended to turn you into lawyers or even to make you experts, legal or otherwise, on the topic of sexual assault. In your work, you likely see women in a variety of situations, and some of those women may disclose sexual assault to you. We want you to be able to give those women helpful, basic information so they understand what options they can consider, and then we'd like you to refer them to the appropriate specialists for more in-depth support. Just a quick note about language. Our work is focused on women, so that's the language I use. We define women to include all those who self-identify as female. Of course, most of the information we provide in this webinar would also apply to men who've been sexually assaulted. The information in this webinar is not legal advice. While we may use examples to illustrate points we're making, these are hypothetical and not real. For that reason, you should not interpret information in this webinar as legal advice, and you should not use it as such with your clients. Only a lawyer who has been fully informed of all the facts by their client can provide legal advice. The information we're providing here is current up to the date this webinar was recorded in mid-December of 2018. But changes to the law, court rules, practices, legal outcomes are common. So you cannot be certain that what you hear today will still be accurate in the future. If you watch this webinar after 2018, you should verify the accuracy of the information in it. Although the criminal law is a national law, a federal law that applies equally to people everywhere in Canada, court processes and many of the other legal options that we discuss in this webinar are specific to the province of Ontario. If you're listening to this from another province, the information about things like the Criminal Injuries Compensation Board, criminal court process, professional colleges, and so on will be somewhat different in your location. Most people's minds immediately turn to criminal law when they think about the legal issues arising from a sexual assault. And indeed, as we will discuss shortly, there are criminal responses to sexualized violence. However, it's important when you're supporting a woman who's been sexually assaulted that you not assume she wants to turn to the criminal law, and that you not treat contacting the police as an automatic or default option for her. The most important thing for you to keep in mind in your initial meetings and discussions with a woman who tells you she's been sexually assaulted is that she is the one who will know best what will work for her. You can and you should ask her what her long and short term goals are to guide you in terms of the legal options you explore with her, but always let her take the lead. You need to be supportive and non judgmental of whatever options she focuses on, while also letting her know if there are any imminent time limitations that she needs to keep in mind. Women have many reasons for reporting or not reporting what has happened to them. Some women want to tell. It may be the police, it may be family members, friends, others in the community. Some women want to report because they want to try to prevent the abuser from doing the same thing to anyone else. Some women think that by telling what's happened to them, they will feel validated that what happened to them was both real and wrong. They may hope that the process they're engaging with will lead the perpetrator to realize that what he did was wrong. They may want to stop him from harming them again, and they may want to affect systemic change. Likewise, there are many reasons that a woman may not want to tell anybody, in particular the police, about what's happened to her. She may feel a sense of shame, as though somehow it's her fault. Fear is a big factor that keeps women from reporting. Women may feel that they won't be believed, that they'll be re-victimized or stigmatized, and they may be worried about becoming isolated from friends and family. Of course, a huge fear for many women is that if they report the sexual assault to the police, there will be reprisals by the abuser. Often a woman may not feel strong enough after a sexual assault to do anything, let alone report what's happened to her to an authority. Criminal court, as we'll see when we talk about it shortly, is a slow process, and many women don't want to tie up the next couple of years of their lives with something like that. Other times, especially if the woman knows the person who sexually assaulted her and still cares about him, while she wants him to stop his abusive behavior, she may not want him to get a criminal record. Sexual assault is a crime in Canada. There are many sexual offenses listed in the criminal code that cover different kinds and levels of seriousness of sexual assault, the age of the victim, the relationship between the accused and the victim, and so on. I am going to talk about the criminal response to sexual assault, but I want to strongly encourage you to refer any women you're supporting who are considering contacting the police to get independent legal advice before they do so. And at the end of the webinar, I'll tell you more about what we do at the Barbara Schleifer Clinic and how women can access this service as well as independent legal advice from other sources. One of the most important and also difficult things for women to understand is that they are not parties in a criminal case. The criminal system is about the accused person. Is he guilty beyond a reasonable doubt of the charge or the charges that he is facing? And if he is, what consequence or consequences are appropriate for him? The woman is the witness. Her role is to tell the court what happened. The criminal process is not about her well-being, or her healing. This is why victims of crime, including survivors of sexual assault, do not have lawyers. And this is why helping a woman access independent legal advice is so important. Because victims of crime have such a limited role in a criminal proceeding, many feel very frustrated by the process. If you support a woman who has been or is involved with the criminal process, she may tell you she feels like she doesn't matter or that no one cares about her. You can validate how she feels and also explain that this is natural, given that the focus of criminal law is the accused and not the victim or the survivor. There are two important principles in criminal law for all of us to keep in mind. First, all accused people are presumed innocent. In other words, just because someone has been charged with a criminal offense does not mean we should assume they have done it. That determination can only be made through a trial where all the evidence is assessed, or if the accused pleads guilty, we can then view them as no longer innocent. The second important principle is this: to be found guilty, the judge or jury must believe beyond a reasonable doubt that the person has done what they are charged with. It's the job of the Crown Attorney to convince the judge or the jury beyond a reasonable doubt of the guilt of the person who's been accused and charged. It's the job of the defense lawyer to poke holes in the case made by the Crown Attorney to try to introduce some reasonable doubt in the mind of the judge or the jury. These are important principles that we do not want to undermine. However, they create unique challenges in sexual assault cases because of societal attitudes towards women and violence, sexual violence in particular, and because in most sexual assault cases, there are no witnesses to what has happened other than the survivor and the perpetrator. Unless the perpetrator pleads guilty, a criminal sexual assault case can take months or even years to make its way through the process. For most of this time, as I mentioned a couple of minutes ago, it can appear to the survivor as though nothing is going on, which can be very frustrating. As with any crime, police are the gatekeepers to the criminal system. They take the initial statement from the victim, they conduct an investigation, and they decide whether or not to lay a charge. It is not the victim, survivor, who makes that decision, it's the police. A sexual assault can be reported to the police right after it has happened or later, even years later. If a woman calls 911 during or immediately after a sexual assault, most likely a uniformed officer will be dispatched to where she is. The officer who will take her initial statement has not necessarily had any specialized training in handling a sexual assault situation. If a woman decides to report the sexual assault to the police later, she can call her local police division or police force to set up a time to come in to make her statement. This should eliminate a long wait in the lobby of the police station, but not always. When she makes the appointment, she should ask to see a member of the sexual assault squad. Sexual assault squads exist in many, but not all police forces in Ontario, and these are officers who have had specialized training. Most likely, her statement will be videotaped, and she will have to swear or affirm that she is telling the truth, just as she will have to do if she testifies in court. Once the police have taken her statement, they will, if necessary, collect evidence and/or conduct an investigation before deciding whether or not to lay a charge. If they lay a charge, the file is then transferred to the Crown Attorney's office. The Crown Attorney is a lawyer, and that person is responsible for prosecuting the case. The woman will be connected to the Victim Witness Assistance Program, or VWAP, where a worker will assist her through the criminal process and facilitate any meetings that happen with the Crown Attorney. If the accused person has a lawyer, this person is called the defense lawyer. If he does not, he can use the services of duty counsel for some of his court appearances. Typically, the bail hearing will take place in front of a justice of the peace, who's similar to a judge, but does not have to have had legal training and does not have as much power as a judge. If the case goes to trial, a judge or jury will decide whether or not the accused person is guilty. Even if a jury is involved, their job ends at this point, and if the accused is found guilty, it's the judge who determines the sentence. The accused will usually be kept in police custody until he has a bail hearing. At this hearing, the Crown Attorney will present what conditions it wants to see placed on the accused, and the defense lawyer will argue that there should be minimal restrictions on the accused. Typical conditions include no contact, direct or indirect, with the survivor, no alcohol or illegal drug consumption, especially if these were involved in the incident that led to the charge being laid, not going to specific locations, for example, where the incident took place, the survivor's workplace or her home. Depending on the circumstances of the incident, a curfew, a requirement to live with a specific person, to turn over his passport, or to report to the police on a regular basis may also be conditions on the bail. The woman can ask her VWAP worker for a copy of the bail conditions. In any criminal case, the Crown Attorney is required to provide all information in the case file to the defense lawyer. This is called disclosure. Women should be aware of this before they hand over their cell phones, photocopies of text messages, emails, or anything else of a personal nature to the police. There are specific rules and procedures if the accused wants to have access to a woman's journal or therapy, counseling, or medical records. If the accused brings such an application, the woman has the right to have a lawyer, and she can obtain a legal aid certificate for this if she qualifies financially. After the bail hearing has happened, and after the Crown Attorney has provided the defense lawyer with disclosure, the two lawyers will have at least one and often several Crown resolution meetings. These are meetings where they discuss whether or not the case can be resolved without having to go to a trial. For example, the Crown might agree to reduce the charge to a less serious one if the accused agrees to plead guilty to it, or the accused might agree to plead guilty if the Crown agrees to a minimal penalty. If there's a resolution, then there will be no trial, but there may still be a sentencing hearing. Whether or not the survivor has to testify and how many times depends on the case. If the accused pleads guilty right away and the Crown and the defense lawyer work out a penalty, she may not have to testify at all. If he pleads not guilty and the case goes to trial, she will have to testify at the trial, which includes being questioned by the Crown Attorney and then cross-examined by the defense lawyer. She may also have to testify at the sentencing hearing if the accused is found guilty. If the accused chooses to have a trial by jury, then the survivor may have to testify at a preliminary hearing, then at the trial, and possibly at the sentencing hearing. If the accused is found guilty, the survivor has the opportunity to write a victim impact statement in which she can talk about the impact of the sexual assault on her. The judge will read this and take it into account when determining the penalty for the accused. Now, let's leave criminal law. Most professions, physicians, psychiatrists, lawyers, teachers, have regulatory bodies that oversee the behavior of the members of that profession. Most of these have internal processes for dealing with complaints, including complaints of sexual assault, by clients, patients, students. Professional regulatory bodies cannot charge a professional with a criminal offense. They can simply impose a penalty within the profession. But a survivor of sexual assault or sexual abuse can make both a complaint to the regulatory body and report what has happened to the police. So one doesn't preclude the other. While each regulatory body has its own process, there are a number of similarities from one to another. There is a complaints committee and sometimes a specialized sexual assault subcommittee. The complaint usually has to be initiated by the survivor herself. It usually needs to be in writing, and it would be submitted to either the complaints committee or the specialized sexual abuse subcommittee. Once the committee has received the complaint, the professional is notified. That notification includes identifying the survivor, who's called the complainant in this process. The professional has the right to respond to the complaint. That response is shared with the survivor/complainant. The committee then conducts an investigation. Depending on what it finds, it may refer the complaint to a discipline hearing, it may caution the professional, or it may do nothing at all if it feels that the complaint is unfounded or they can't verify it. Some regulatory bodies provide funding for therapy for survivors, regardless of the outcome of the complaints process. Others only provide this funding if there has been a finding of misconduct. Some provide survivors with access to legal assistance through the complaints process. So these are the common elements that appear within most regulatory bodies in Ontario. If you're talking with a woman and trying to support a woman who wants to investigate making a complaint to a specific regulatory body, you should look up that body online. They've all got websites, and their complaint processes and their specific complaint processes for sexual assault and sexual abuse appear on those websites. Some women are interested in making an application to the Criminal Injuries Compensation Board, or CICB, or board. The CICB can provide financial compensation up to $25,000 for injuries that are the result of an act in the criminal code. The funding comes from the provincial government, not from the abuser. There are some eligibility criteria. The crime must have been one of violence, and it has to have taken place in Ontario. There's no limitation period for sexual assault, domestic violence, or childhood sexual or physical abuse claims. So if you're talking to a woman who was sexually assaulted 20 years ago, this is certainly an option that you can present to her because there is no time limitation. It's also important for women to know that no charges or convictions are necessary for a CICB claim to be successful. In other words, even if the woman's never reported what happened to the police, or perhaps she's reported and they did not lay a charge, or they laid a charge but the fellow was acquitted, doesn't matter. She can still make an application to the Criminal Injuries Compensation Board. The process is intended to be manageable by the survivor, who's called the applicant in this proceeding, on her own. And it can be found along with the application form on the CICB website. And we've given you that address on your slide. The evidence is very important. And the evidence that a woman should include with her application includes such things as statements from any witnesses, support letters, police occurrence report if there is one, a charge sheet or proof of criminal conviction if there is one, and medical and therapy records, as well as proof of any out-of-pocket expenses that she's incurred as a result of the sexual assault. The applicant must prove that it is more likely than not that the crime has occurred. So again, this is not a criminal proceeding. She doesn't have to prove it beyond a reasonable doubt. She simply has to have enough evidence to persuade the Criminal Injuries Compensation Board that it's more likely than not that she was sexually assaulted by this individual. If the board can find the abuser, who's called the respondent in this proceeding, he may be given notice of the application, but the survivor can request that he not be notified if he has already been convicted or if she is afraid of him. Even though he is provided with notice, that notice will not include any personal contact information about the survivor. Once the board has reviewed the application, it will set up a hearing where board members will ask the survivor questions. If it's an in-person hearing, which is not the norm, and if the respondent participates, he will not be in the same room as the survivor. It generally takes about a year for an application to make its way through the criminal injuries process. The process certainly moves more quickly if the initial submission by the survivor is complete and detailed. A Criminal Injuries Compensation Board award can compensate for a number of things. It can compensate for medical bills that go beyond what OHIP covers, the cost of prescription medication, other out-of-pocket costs like replacing clothing, replacing furniture, and so on. It can cover lost income or wages. The costs of therapy and counseling can be covered, and then the CICB award can also compensate for pain and suffering. An award for pain and suffering will not affect social assistance if the survivor is collecting OW or ODSP. Loss of income awards will be considered income for the purposes of social assistance, and loss of wages awards may reduce the amount of Ontario Works or ODSP. A woman may decide to sue the person who sexually assaulted her, especially if he is extremely wealthy or if there is institutional responsibility, for example, a school board, a church, a hockey team, so on, for the assailant's actions. Any woman considering such a lawsuit should speak with a lawyer who specializes in civil sexual assault cases. The Schleifer Clinic can make referrals to these lawyers. There's no limitation period for sexual assault civil suits, so this is not something a woman needs to decide right away. In some situations, a woman can bring a human rights complaint to the Human Rights Tribunal of Ontario, or the HRTO. The HRTO can provide damages to the survivor, but can also affect systemic change. If the sexual assault has taken place while the woman is at work, receiving services, for example, healthcare, if it's in the context of her housing, or in a few other situations, this can lead to a complaint to the HRTO. She can access legal advice and assistance when she's preparing her application and at each stage of the process from the Human Rights Legal Support Center. The application form and a description of the process can be found on the HRTO website, and we've given you that that website address on the slide. There is a statute of limitations to bring a complaint to the HRTO. The application must be started within 1 year of the date of the incident. Every college and university in Ontario must have a sexual violence policy with clear procedures for how the institution responds to reports of sexual violence. Not all policies are the same, so a woman needs to become familiar with the policy at her institution to be sure the reporting process will work for her. She can report to the police whether or not she also files a report within her academic institution. This is really important. If you're working with students, often they feel pressured by their academic institution to keep it private, to keep it within the school. They don't have to do that. If the survivor of the sexual assault wants to use a complaint process within the school on its own, great, that's fine. She can do that. If she wants to go to the police only, she can do that. And if she wants to do both, she can do that as well. That's her choice. It's not up to the academic institution to make that decision for her. Employers also have obligations to respond to allegations of sexual violence in the workplace under the Occupational Health and Safety Act. As well, in some unionized workplaces, there are further requirements in the collective agreement. As with universities and colleges, professional bodies, a survivor of sexual assault can report to the police whether or not she also follows her internal workplace policy and procedure. You're most likely seeing women in the context of other issues they're dealing with. An ongoing client may disclose a sexual assault to you, recent or historic, in the course of other work you're doing with her. Or a new client may disclose it in the course of doing intake with you. There are a few things it's important for you to determine with a woman as soon as possible. Does she need medical attention right away? If so, how can you assist her with that? And secondly, does she need or want legal advice? It's really important for a woman who's been sexually assaulted to get independent legal advice as soon as possible, and certainly before she makes any decisions about reporting or not reporting to the police. This advice should come from a lawyer who has experience with sexual assault, especially with supporting survivors, and who understands the pros and cons of different legal options. This lawyer cannot represent the woman if she goes to the police and charges are laid, because victim witnesses don't have the right to be represented in criminal court. But the lawyer can help her prepare for her interview with the police, debrief with her afterwards, explain the steps in the criminal process, and so on. Unfortunately, Legal Aid Ontario does not provide certificates for survivors of sexual assault who want to consult with a lawyer, which means women with limited financial means have few options. One good option is a program funded by the Ministry of the Attorney General. Through this program, sexual assault survivors in 3 regions of Ontario, Ottawa, Toronto, and Thunder Bay, can get free independent legal advice. Private lawyers can provide this advice through this project. A woman who's interested in this needs to complete the voucher request form, which can be found on the Government of Ontario website, and we've given you the address for this in your slide. There's more information about how the project works on the MAG site, also on your slide. Lawyers at the Barbara Schleifer Clinic provide this service at our office, by telephone, and at other agencies. We're able to offer a wraparound approach with the legal advice supported by counseling and language interpretation, if this is what the woman wants. If you have a client who would like to receive free independent legal advice from a lawyer at the Schleifer Clinic, she should contact our intake team. She does not have to work through the voucher system as she would if she were using a private lawyer. We've given you the telephone number for the legal intake team on your slide. If your primary role is not counseling, you should encourage any client who's been sexually assaulted to seek counseling, especially, but not only, if she's planning to engage with the criminal process. Counseling will be very important for her emotional well-being. There are a number of places a woman can get counseling support that's specific to sexual assault. Some agencies and programs offer both individual and group counseling. The Schleifer Clinic offers counseling as well as legal services, so women can call our intake line to set up an appointment with one of our counselors or to join one of our groups. Most communities in Ontario have community-based sexual assault centers who provide similar kinds of support, and most communities have one hospital that has a domestic violence sexual assault treatment center. Women can contact any of these agencies if they're looking for counseling support. Many women have safety concerns after a sexual assault and/or when they report to the police. This is especially true if, as is most common, the person who committed the sexual assault is someone she knows. The assailant may have threatened her or may be stalking her to try to convince her not to tell anyone about what he did. Helping her make a plan to be and feel as safe as possible is important. If you already do safety planning with your clients, you'll have tools that you're familiar with. If you don't, there are a number of good tools available online. You should look for one from a feminist agency that works with women who've experienced violence. One good model is from the Peel Committee Against Women Abuse, and you can find the link to their safety plan on your slide. We hope you found this webinar helpful. If you'd like more information about the Schleifer Clinic or this topic, I encourage you to get in touch with us. Our contact information is here.